Good morning, all. The hearing is in the matter of CFI 5/2021 before Registrar Nour Hineidi and is being held by way of video conference. The claimant are represented by Nimble Legal Consulting FZE. Lead counsel is Justina Stewart, and the defendant is represented by Curtis Mallet Provost, Colt, and Mosley LLP. Lead counsel is Antonia Burt. Thank you.
Thank you. Fantastic. Ms. Stewart, I understand that it's your client that has made the application in question, and we need some directions for the progression of that application. A skeleton came through quite late in the morning, so unfortunately, in full transparency, I haven't had the chance to read it completely, but perhaps you can walk me through what directions are being sought by your clients today, and then Ms. Burt can provide her responsive submissions and we can go from there. Thank you.
I'm grateful. May I ask, apart from the skeleton argument, and I apologise it came in late, there was a bit of confusion at our end, I understand. What else have you had the opportunity to read? Have you had the opportunity to look at the witness statement yet in support of the application?
I have not read it in a huge amount of detail, to be brutally honest with you, only because I won't be determining the application today, obviously. I think we're only making directions for the progression of the application. I may well end up making a decision on the application. I've got to discuss that with the judge. But if you could give me a high-level synopsis of what the witness statement is about. I'm sorry, Ms. Stewart, typically I'm very well prepared for these hearings, but we have been incredibly under the pump. So no excuse, but
no, I'm grateful you were able to
Thank
fit
you.
us in. So in terms of the agreed issues for determination today, I've summarised those at paragraph 10 of my skeleton argument. So the listing of the application, as you may have seen, we've sought an expedited hearing. The application was issued on the 5th of April, having sent the request for further information on the 22nd of March, so some 4 weeks ago. If we work backwards from the PTR date of the 29th of July, and taking into account the various procedural steps that would ideally, I know that PTR isn't intended to be a guillotine, but you ideally want to be in pretty much there. So taking into account the procedural steps that would ideally be reached before then, we would seek a listing on the first available date from the 9th of March, and on no later than the 9th of May, and on no later than the 13th of May.
Sorry, 9th of May. I keep thinking we're in March, but we're actually in April. Okay, so 9th of May. And just to recap, I saw an email and I remember issuing an administrative stay on the application. Was it the case, Ms. Burt, that the evidence in response to the application was due yesterday? Is that right?
Yes, that's right. Exactly. The evidence was due yesterday, and we understand in the skeleton this morning, the claimants have proposed a new date in light of the registrar's directions that the deadline yesterday was to be suspended for the time being.
Okay.
Going on to that, now we would note that Curtis, if you pardon me using the abbreviation, Curtis stated on the 15th of April that the defendant is ready to file her response to the application. Now, we've put in a date here that if they're somehow finding that difficult, then they could file and serve their evidence by 4 p.m. on the 27th of April. So that would give them a week from now. Although I must say that you may find that that's overly generous in the circumstances. And then going on to our evidence in response to that, if any, I mean, obviously it depends on what they file, but at this stage we say that the matters can pretty much be determined on the state of the pleadings, which speak for themselves. But if we do file any evidence, then if we could have a further week after that. And then in terms of the final issue that's agreed is order as to cost for today, we would quite simply say order in the costs in the application. Now, moving on to perhaps a more contentious aspect of this hearing is that the defendant's issue for this hearing, and we don't agree with it, is whether statements in the main proceedings should be filed before the application's listed. As you may have seen from the application, the crux of what we're saying is we need to have these responses to the requests in order to know the case we're answering, so that, you know, to get to that next stage of witness statements. Now, we say, for that obvious reason, it would be wholly inappropriate to have witness statements before getting the responses to the requests back, which in turn means that the application has to be heard. As contrary to previous indications, it now seems that the defendant is going to defend this application. Now, in terms of, I don't know whether, the thing is, this has been listed for a short directions hearing, not the hearing of the application itself. So given that it's central to the issue about the witness statements as to whether we understand the case, in a way, we have to predetermine the application. Now, we would say, now I can, or to seek witness statements in advance or to grant them would be, in essence, granting that or prejudging that application. Now, I can go into the pleadings themselves and explain the very obvious problems we would submit, and I can do that quite simply in the first instance by way of example, if that would assist. I'm not seeking a determination of the application, but although that would have been nice, but but it might give you an idea as to the problems we're experiencing. I don't know if that's necessary given what you've read.
I have an idea about the gap that the claimant claims is currently apparent on its case. So it's saying that essentially it doesn't have access to certain documents that the defendant is producing, and for that reason, it's not in a position to essentially put together witness statements.
It's not quite that. It's more fundamental than that, I'm afraid.
It's a lot more fundamental. Okay, so if you could just walk me through, Ms. Stewart, an example, that would be very helpful.
Okay.
Thank you.
If I could draw your attention to W124.
Just bear with me, please, while I pick up the bundle. Now, very strangely, I've only got up to W. Oh, okay. Sorry. 493.
Case line crashed on me last night, so I ended up getting it all printed, I'm afraid.
Oh, really?
Yeah,
That's good feedback. Yes.
Apologies, it doesn't seem that we have access to this bundle at all, so I'm not sure what bundle this is, but I can't find it at the moment.
You should have. But in any event, what I'm referring to, Ms. Burt, is paragraph 33 of the amended defence and counterclaim. And this is just an example, incidentally.
Now, this is very strange because I can't find the document at all. My bundle goes all the way from W80. 81, let's have a look.
It's, if you look at the...
Oh, okay. It's is it under the exhibit bundle, HGK2?
Yes.
Which is tab 11. Okay.
Yeah.
And it was page 124.
W124, or page 23 of the exhibits.
Now, I just want to confirm that Ms. Burt, so typically any bundles exchanged before any kind of hearing before the court needs to be done with discussion or on discussion with the other side. So it's a little bit concerning that Miss Burt hasn't had access to the bundle, and I couldn't see a skeleton filed by the defendant either. So just moving forward, obviously this is a short directions hearing. It's not major, and I know that skeletons are typically provided by counsel to aid the court in submissions. But ideally, just for future reference, future practice, it would be good if the parties could have discussions on bundles and skeletons ahead of the hearing, or seek directions from the court as to the exchange of such documents before the hearing, so that everyone's on the same page, so that Miss Burt could have had also the opportunity of preparing a skeleton in case that's what she wanted to do. So Miss Burt, you don't have access to the bundle, but you obviously do have access to the exhibit. Is that right?
Yes, that's right. I don't at the moment seem to have access to the bundle. There was an email, I think late on Monday, in which the claimants had proposed the bundle, and we had responded to it yesterday saying that we didn't consider that it was proportionate for this brief directions hearing, and we didn't then receive any response. So I must admit that we had assumed no bundle had been filed. Maybe it has been filed, and I haven't noticed, in which case I apologize. But I do have access to what Ms. Stewart referred to, which is the amended defense, and I'm at paragraph 43. So I do
the
see
so-called bundle is merely just for transparency. The so-called bundle comprises the application. It basically is the application notice, the draft order in support of the application, the witness statement and the exhibits to the application, and then the correspondence since then with the registry. So I'd submit that, just to be clear, I don't think there's any prejudice. There's nothing that my learned friend won't have seen already. And that's just...
I think that's very fair, and I don't disagree with that, Ms. Stewart, but I think so that everyone's on the same page throughout the hearing, it's usually a lot easier that we all work off the one bundle. But obviously you wouldn't have known that Ms. Burt didn't have access to it, so I'm not obviously going to penalise anyone. It's just as a matter of good practice, good for the parties to have that dialogue ahead of the hearing for next time. Anyway, yeah. So page 124, W124.
Okay, so we go to paragraph 33, and if I'm to understand correctly from these pleadings, this is really the crux of the defendant's case. Now, so what we have is breach terms of the employment agreement, duties as an officer, and all kinds of other alleged duties. If we look at 33.1, and these are presumably the particulars in support, we've got sharing the entertainer's confidential information with third parties. And there are many references to confidential information. And it's somehow said in this paragraph that this confidential information, which is not particularized, somehow caused loss. There is an allegation that there was a secret plot. We see that at line 3 of 33.1, as set out in some detail in Mr. Krishna's second statement. There's extensive documentary evidence that well before the settlement agreement was entered, the defendant had been provided with documents mentioning an MBO. So we simply don't understand in what way, what was it that was secret? And therefore, when did this awareness of whatever it was that was secret come to light? We then come to the next point about substantial free equity. Well, what does that mean, free equity? Then going on, we move to highly confidential information. We move to an allegation of without obtaining consent, which all goes to this secret plot about whatever secret it was. So then we have this paragraph, which is all about third parties, some general allegation of confidential information. And then it says, as a result of such misconduct, the claimants caused a loss of value in the business sale. So that refers to everything that was in 33.1, confidential information, third parties. And then there seems to be some attempt to narrow it down, but it's all very confusing because the first part refers to third parties, and then the second part talks about a competitive tender process. Well, what competitive tender process? What exactly is being discussed? And then it says that the transaction value was negatively impacted given that GFH Group, so we're now not talking about multiple third parties, we're talking about one GFH Group. So there's already been a shift within the first subparagraph. Then it says they were able to structure their offer on the basis of confidential information. So apparently this is what caused a loss in value. Well, how were they able to structure their offer? What exactly is being alleged? And how is that structuring related to the confidential information? And how did that structuring actually cause a loss in value? We do not, I've been through all of the disclosure. The legal team, those instructing me have, really mystified. That's just one example. There are numerous other examples of things that we've asked for, further information that we've sought, which frankly, should have been provided by now. Proper particulars should have been given, but they haven't been.
So, Ms. Stewart, what's the date of this amended defence and counterclaim?
The amended defence, and I concede that this amended defence and counterclaim, it's dated the 13th of July 2021. In Mr. Krishna's statement,
it talks about the delay in filing this request, is that right?
Yes, and hands up, we appreciate that. He explained that there was a change of legal representation as soon as he came on board. He had to deal with disclosure applications. We had the order, and I wasn't involved at all with those disclosure applications, so I'm not even going to try to talk to them, but or not to talk to them in any detail. But came on board at the beginning of March, and it was then in earnest that efforts that we started looking at what was actually in the disclosure. And there had been, one of the problems that Mr. Krishna had experienced is that there'd been essentially a data dump during the disclosure process by Curtis, which had taken up extra time for him to try and work out what on earth was going on. And none of this was assisted by the way that the claimant's previous lawyers had actually dealt with the matter. So it is unfortunate, but the good news from our perspective is that there is sufficient time in the timetable to be able to get this clarified now and to get this back on track in some kind of sensible form.
Okay, that's helpful. Thank you. Was there anything else you wished to add, Ms. Stewart? I think that's a good example. But was there anything else that you wish to add on this particular note before I hear from Ms. Burt?
Well, I think the key issue is that the defendant's response seems to be that we'll discover the case from the forthcoming witness statements upon exchange. With the greatest of respect, witness statement does not constitute a statement of case and should not be a substitute for a properly particularized statement of case. And I think though that's all I have, subject to what Ms. Burt may say.
Thank you, Ms. Stewart. Ms. Burt, over to you. Thank you.
Thank you very much, Madam.
Sorry, Ms. But if we can just perhaps get the timelines out the way for the progression of the application, we'll start off with that, and then we'll go into your response on whether witness statements and the main proceedings should be filed before the application is listed. So 4 p.m. on the 27th of April, I think, you know, it is quite generous. Are you happy with that date, or do you think you can get the evidence and answer across to the claimant before that date?
Sorry, I think you cut out for the last second, but I wanted to say in any case that yes, in terms of the dates, obviously the date proposed is absolutely fine, and we could certainly do earlier. So our option that we had considered prior to receiving the skeleton was to make the submission next Monday, so the 25th. So it would be, you know, sort of kind of two business days from after the hearing, which is absolutely fine from the defendant's perspective. So that's what we were planning to offer, but obviously happy with the year 27. And in terms of the reply, also we have obviously no objections at all if the claimants would like 7 days to reply. The only small query would be the date for the hearing, because first of all, we need to check with our counsel in respect of availability. And I do seem to recall that the particular 5 days that had been proposed have in fact been discussed on a separate matter recently. And I seem to recall that our counsel was not available. So without kind of putting anything in writing for the time being, but we would like to come back later today with respect to the hearing date. And then subject to that, it can either be scheduled that week or the week after, but that's obviously absolutely fine.
Just in terms of timelines and listing the hearing, I'm conscious that the judge is actually not available for a good bulk of May and June. So it's very likely that he will ask me to hear the application. In terms of my availability, I've got very limited availability from about the 12th of May. So it would have to be listed before that date because I'm then at capacity with hearings essentially until the end of May. So that's something to think about, and it's something I think we need to work on very quickly. But given that you're open to having the evidence and answer to the court and service on the claimant by the 25th, let's do the 25th, please. Which is great news. So thank you, Ms. Burt, for accommodating an earlier date. Ms. Stewart, do you still need a full week, or do you think if you were to get this to the court by next Friday, you can have as long as you need, or even by Sunday, then the application is essentially fully pleaded in case you've got evidence and response. It's fully pleaded before Monday morning the following week.
Sorry, fully pleaded. As I understand, so we get the evidence on the 25th, and then the problem is we don't know what's going to be in that. We don't understand why this is being opposed, this application. And despite the fact that there's been very lengthy correspondence from Curtis, we still don't understand the substance of the opposition. So the other problem is that I'm in the States next week, and ordinarily traveling wouldn't be a problem, but there is, because of the time difference with the States, it is more problematic. So I just wanted to have, just in case there's anything that those instructing me would like assistance on.
Well, it's actually occurred to me, sorry to interrupt you, but it's occurred to me that we're actually on a public holiday anyway during that time. So I may struggle to review anything on the 2nd. So why don't you have until the 3rd? So close of business on the 3rd of May. So that gives you a bit of extra time, even a bit longer than the week, to have your evidence and response, if any, by that date. And then fresh on Wednesday morning is when we can start review, and then essentially it's ready to be listed anytime after the 4th of May. So for the record, the administrative stay on the application is lifted. The date for the defendant's evidence and answer, if any, says well, evidence and answer, because the defendant has confirmed that they will get evidence and answer in, is due by 4 p.m. on the 25th of May. The claimant's evidence and response, if any, is due by 4 p.m. on the 3rd of May. and the application is to be listed shortly thereafter, from a date between the 4th and I would say the 11th of May. This has been set as a heavy application, if I'm not wrong. Is that right? So requiring a hearing of more than 3 hours?
I'd be surprised if it requires more than 3 hours.
Okay. Ms. Birch?
I understood it was requested by the claims over the hearing of less than 3 hours.
Okay.
And in fact, we had suggested that it may be heard on papers, but yes, so I don't think it's a heavy application.
Fantastic. That's great. So yeah, if we can deal with it on the papers, that's even better, because it means that it's probably a little bit faster. But in fact, my style sometimes is just to take this to hearing, flesh it all out, hash it out together, and then get a response on the same day right away. So if it needs to go to hearing, then it will be listed before the 4th and the 9th, and that's for the purposes of the draft order that we'll prepare after the hearing today. Great. So Ms. Birch, over to you for your submissions in response to the exchange of witness statements.
Thank you very much, and I will keep it brief, because all we were suggesting was to try and keep this process slightly more efficient and cost effective, because we are concerned that there's all kinds of duplication that is being requested. But there are a couple of points that have been made by Ms. Stewart that may be worth just responding to very briefly. Maybe starting from the back of the comments, the substance of our opposition has in fact been made clear from our very first letter. So if Ms. Stewart was already involved at that stage, please feel free to have a look. We have set out 6 grounds on which this application should be rejected. And that also goes to another point that Ms. Stewart made, which was relating to our parent position that the claimant should discover the case and witness evidence. That's absolutely not right. That is not something that we have said at any point. The application is completely meritless for at least 6 reasons that we've already set out in correspondence, none of which have to do with discovering the case and witness evidence. Our position is very clearly that the pleadings are more than sufficient to set out in fact, overly detailed at 26 pages, setting out the case that the claimants have to meet, which of course the claimants are fully aware of, having met it for at least a year until Ms. Stewart joined the matter. And I appreciate that maybe some of this is related to Ms. Stewart joining the case late, but of course there have been, including in the disclosure application, already pages and pages of evidence about this exact case. And coming very briefly to the point that Ms. Stewart made relating to the paragraph 33 of the defense. Again, I don't think that it's absolutely helpful at this stage to go through the particular application, but I did think that that example was a perfect example of our objection to the application, because of course the case is stated very clearly, and Ms. Stewart and the claimants do not understand what was secret. But what Ms. Stewart actually said was that the claimants disagree with the fact that it was secret. The claimants have at all times understood, and it is clearly stated in the pleadings, that it's the attempted management buyout that was the secret plot. And that is stated clearly, and it has been defended by the claimants at many occasions. And all the claimants are saying now is that they disagreed, that this was secret. That's not a matter ripe for request for information. It is simply a disagreement with our case, which of course will be addressed at the appropriate forum. And all that we have said in terms of our proposal to deal with this application somewhat more efficiently was that, in addition to the fact that the application is not warranted for at least 6 reasons that we've set out in writing, so there are no surprises there. But in addition to that, in fact, what we think is that many of the requests, I think the vast majority of the requests, actually go to evidence rather than the pleaded case. And we do say that because the timing of the application was 1 day before the evidence was due, it is simply not proportionate for that reason for the application to proceed before evidence. which is why we had suggested that the evidence should come in, because each of the questions that Ms. Stewart addressed with respect to paragraph 33, while, as I repeat, our primary position is it has been fully sufficiently pled in the pleadings, it will be in much more detail set out in witness evidence, as it is typical for this kind of proceeding. And therefore, we do think that a lot of, possibly the vast majority of the requests would in fact resolve themselves simply if the parties were able to file the statements that they have already close to prepared. And that was all that we wanted to suggest. We are certainly not pushing for this proposal in any particular way. We had suggested it simply as a matter for initially the claimant's approval, and then following the claimant's failure to approve for the same, we had suggested it to the registrar as an option of being somewhat more proportionate in our view, because as we say, we do think that if the witness evidence is filed first, that many of the requests will simply go away. Our proposal, and we apologize, we did not file skeletons as we didn't think it was required for this brief directions hearing, but our proposal would have been to file witness evidence, also to file our reply to the application, of course, because we are not suggesting it should be prejudged in any way or not determined, but simply to give the claimants another opportunity, once we have filed both statements and the reply, to consider whether they are continuing with their application or in how far, or potentially to cut it by 70% or so, and only resolve the remaining aspect. And we do think, in terms of when the application was made, that is the more efficient and proportionate way to resolve it. So that is all that we were proposing, and probably all that I will say for the time being. But we are, of course, in the registrar's hands.
If I might briefly come back on a couple of those points.
Go ahead.
There's been much mention of many pages. Pages does not equate to substance. Very simple point. And I can assure Madam Registrar and my learned friend that I've looked in detail at the papers, and they do leave us none the wiser. Now, my learned friend says that the fact that we say that there was nothing secret about the MBO means that somehow this is a complete answer to the request. That can't possibly be right. What's absolutely clear, and what isn't disputed, is that, as far as I'm aware, that there is documentation, extensive documentation, which refers to the MBO, which the defendant saw. So if it was secret, when did an awareness come about? Given not least that the claimants were employed for a long time after the completion of the sale, and for a very long time after the entry into the settlement agreement. Further, my learned friend said nothing about the confidential information, no particulars still provided, no indication of what the so-called competitive tender process was, no indication of the link between confidential information and the alleged drop in value, or any relationship to the structure. It's not for us to second guess, and any properly particularized claim would set out very simply what that case is. And it's what is really quite troubling is that the requests were not simply responded to. They should, particularly if they say that they were drafting witness statements, they should be able to respond to those requests very swiftly, very promptly indeed. So why is it 4 weeks later we don't have a response? Final point, my learned friend talked about the timing of the application, and she talked about the application was made one day before witness statements were due to be exchanged. Now, witness statements were due to be exchanged on the 6th of April. In fact, we sent the request on the 22nd of March. And frankly, we bent over backwards, extending time, sending consent orders, all kinds of things in order to try and resolve this matter. So to say that this was somehow sprung on, or to try and insinuate that this was somehow sprung on at the last moment, as in the day before witness statements were due to be exchanged, is simply wrong.
Did the parties agree to defer the exchange of witness statements on the basis that the application was served on the 6th of April?
No, that was never agreed.
That was, so no witness statements were filed in the end?
Correct, because we applied the day before to extend
Okay.
the date.
Oh,
That's
to extend the time for the
Yeah.
exchange of witness statements. I see. Look, to be honest with you, I think it's all much of a muchness. I think the defendant is saying these requests are better addressed in the form of witness statements, and at which point the witness statements are exchanged, you will have your answers to your requests, and your request will be redundant. And you're saying, Ms. Stewart, that it's in better form and better practice that the requests are addressed in the form of a pleading. I think that in the defendant's case, and to assist the defendant's case, I think Ms. Burt is suggesting that certain documents might be exhibited to the witness statements, which might help address the queries subject of the requests, whereas you're saying that the requests are much better articulated in the form of a pleading, so that you can then go back and perhaps even amend your pleadings if necessary. Is that right?
I don't, that's not what Miss Burt is saying. Miss Burt is saying that we know what the defendant's case is. We're not, there has been disclosure now. The disclosure phase is over. We have the documents.
Right. But Miss Burt,
there's no suggestion that further documents are going to be exhibited. And certainly if that's the intention, they should have been disclosed by now.
And just to be clear, they have, of course, been disclosed. And, you know, while I don't understand why there's a complaint that, you know, the defendant is currently not responding to the application, since this is, of course, not the hearing of the application. But to be clear, of course, the documents have been disclosed, and any confidential information, all the aspects of the case that the claimants say they do not now suddenly understand are, of course, in the disclosure. So if potentially claimant's counsel cannot connect the dots for the time being, that is not because the documents are not there. All our evidence is in the disclosure. And as Ms. Hineidi was suggesting, of course, will be included together with the evidence. But to be absolutely clear, it's not new evidence. It's already existing disclosure.
It will simply be mapped out in the witness statements, as I understand, because
exactly.
You did mention, Ms. Stewart, that there was a dump of documents on your solicitor firm, and it was difficult to map out what belonged to which issue, for example.
No, that went to the timing and how much extra time that those instructing me spent. The key point here is it's certainly something that I've experienced in a reasonable commercial claim, where you're going to exchange. So this isn't sequential witness evidence. This is exchange where you do not have proper particulars.
I understand. Look, I think my position is this. I think it's better that we do defer the witness statements for the moment until the application is fully pleaded. It might mean, though, that the parties will need to work very fast to get the witness statements in so that we are meeting the procedural deadlines. I don't see the point of filing the witness statements now and then going back to the application in case it's still necessary, which it very well could be. And then we've wasted some more time, because then you've got to file supplemental witness statements, and that's going to throw away costs, and it's not a good outcome. So let's defer the witness statements for now. Let's focus on the application at hand, have it progress as quickly as possible. And then we can deal with the witness statements after the application has been determined. Okay, so Ms. Stewart, was that, and sorry, on the final point, in that regard, we could have obviously allowed for supplemental witness statements, but I don't think there's a need for us to go back and forth at this stage. So yes, let's stick to fully pleading the application, and then we can set deadlines at the application hearing for the exchange of witness statements if we have some outcomes by then.
I'm grateful, thank you. And if
Mm,
I
thank
could
you.
just make one plea, which is if the defendant could quite simply respond to the request, that would be, and then we can just get on with the substance of this matter, that would be even more helpful than spending more money and the court's time on yet more paperwork.
If we could make a similar request for you to discontinue this meritless application, and that would really allow the case to proceed. But yes, just to say thank you, Madam Registrar, for the directions. That's absolutely fine. We do reserve our position on costs because we do consider that this is just 70% or so a wasted exercise. So we will make that point in the application hearing at the time.
We'll keep costs in the application, so we'll make that order. If the parties could please agree a draft order and circulate it to the court by 3 p.m. today, that would be super.
Thank you very much.
Thank you very much.
Thanks very much, everyone.
Thank you. Bye-bye.